Welcome everyone, and thank you for joining today's webinar on the Employment Rights Bill, also known as the Labour Reform. I'm Roxy Gibson and I head up the HR advice and iTeam support here at Agilio. Our goal today is to help you understand the proposed changes in the bill that are under Parliament consultation at the moment and how you can get ready so that you are compliant. So whether you're a principal owner, practice manager or team leader, this session will give you the knowledge to bring you up to speed and how you can prepare yourself. So before we dive into the details, let me give you a quick overview of today's presentation. So we've got the agenda just there. So we'll be walking through the timeline of the key labour reforms and follow the passage of the new bill. This timeline will highlight the changes you need to be focusing on now and how to prepare. And one thing I do want to say is I will publish the timelines and actions that you need to take following this webinar. So please don't worry about trying to capture this as we go through, because there is a lot of information that I will be going through. I don't want you to feel overwhelmed with it all. So we will try and break it down for you on what you need to know and when and what you need to do. But more importantly, we'll share those timelines and actions with you. So we'll start with looking at the immediate changes, which include repealing restrictive legislation and introducing protection for industrial action. Then we'll move on to phase one, which is scheduled for April 2026, where we'll see major improvements in redundancy protections, parental leave, whistleblowing and trade union rights. Then we'll look at the changes that are planned for October 2026, which is phase two. So this focuses on workplace fairness and they look at ending the fire and rehire, improving pay and social care and strengthening harassment protections. Finally, in 2027, we'll explore reforms aimed at inclusivity and long-term worker support, including gender equality measures, protections for pregnant workers and the end of the exploitive 0 hours contracts. We'll wrap up with a summary of the key changes, their expected impact and what comes next in terms of implementation and getting yourself ready and how Agilio will support you. So let's begin with the immediate changes following the bill's passage. Before I head into some of the detail in the bill, I want to add a caveat that some of the changes that you'll see in here that we'll discuss won't impact your business either due to the sector that we work in or the size of your business. But I wanted to give you an overview of all the proposed changes so you're aware of everything that's coming. But then I'll give you more details on the changes that will impact you. If you've got any questions as we go along, please feel free to add them into the Q&A chat and I will try my best to answer as I go along. If not, there will be an opportunity for you to ask more questions at the end and I'll review any questions within that chat as well. So by April 2026, we'll see a significant expansion of worker protections and benefits. So the maximum period for collective redundancy protective awards will be doubled, offering greater financial security to claimants. Day one paternity leave, which is currently eligible from 26 weeks of continuous employment, and unpaid parental leave, which is currently eligible to employees after 1 year's employment, will be introduced so to support family life from the start. Whistleblowing protections will be strengthened to safeguard those who speak out. Day one rights and protection and any sexual harassment claims will be explicitly recognised as a form of whistleblowing. Also, a new Fair Work agency will be established to oversee and promote fair employment practices. So most employment rights are currently enforced by individuals when they present a complaint to an employment tribunal. The Fair Work agency that is being introduced will bring together existing state enforcement functions and over time take on enforcement of a wider range of employment rights. So this will be a single place where workers and employers can turn for help. Statutory sick pay will be reformed to ensure more equitable access. So the qualifying period will be removed. So there's going to be no more waiting for 3 days. And the lower earnings limit that is currently in place is going to be scrapped. And instead of a flat rate of SSP will be calculated as a percentage of earnings. And finally, trade union measures will be modernised, including recognition rights and electronic balloting. So this isn't something that you would always come across regularly. And if you're ever faced with any industrial action, then we would always let you ask to get in touch with the team, where we can guide you through that. So moving into what's planned for October 2026, the focus shifts to workplace fairness and safety. And as I explained earlier, some of which won't be applicable to your business, but it's worth noting. The controversial practice of fire and rehire will be ended. So employers will be prohibited from using fire and rehire as a negotiation tactic without first engaging in meaningful consultation and exploring alternatives. So this isn't something that is widely currently used, but it is an opportunity to be able to use it at the moment if you needed to, if you were proposing contract changes and you were finding that your team members weren't agreeing to those changes. This is something that we have discussed with members before about as an option, but this is going to be taken away. That that isn't going to be an option from October 2026. Our HR best practice and our advice would always be to consult anyway, but now this is becoming a necessity. This is something that you have to do from October 2026. In the first draft of the bill, there was an outright ban on fire and rehire, but this has now been amended, and the ban is going to only apply to restricted variations, which makes it sound like there's going to be more scenarios where you can apply this to, but that isn't actually the case, because the restricted variation still covers things like if you were looking to make a change to hours, pay, pensions or holidays, this is still going to be covered by the ban, so you wouldn't be able to use that in that situation. You would have to go through the full consultation process. So this is going to be a big impact for businesses. There's also going to be new provisions set out so that employment tribunals will need to consider when assessing the fairness of a dismissal in a fire and hire situation. So this will help employers ensure compliance when making these decisions. This also includes agency workers and is based on a 12-week reference period and suggests workers to be given guaranteed hours. So we do have a lot of time on this one yet, but this is something where you may want to consider reviewing your contracts to include a variation clause if they don't already include one. If you currently use the I comply contracts, there is a variation clause within that, so that isn't something that you need to worry about. Employment tribunal rights for employees is going to be extended from 3 months to 6 months after termination. So that gives ex-employees more time and opportunity to submit a claim if they feel that they have a claim to be pursued. So we can probably expect that more ex-employees will probably take that opportunity to do that. Not so relevant to our business, but it's worth noting that there is going to be a fair pay agreement that's going to be introduced for adult social care workers, which addresses long-standing pay disparities. Again, not always relevant, but worth noting, tipping laws will be reformed to ensure workers receive what they earn. So new measures will be implemented to prevent sexual harassment. So you may remember last year I did a webinar relating to some changes in terms of sexual harassment prevention, and we released some articles on this. So there is going to be a further change. So last year, employers had to take reasonable steps to prevent sexual harassment. Employers will now have to take all reasonable steps to prevent sexual harassment and prevent third-party sexual harassment in the workplace. So at the moment, there isn't guidelines set out detailing what reasonable steps look like, but as part of this change, there will be guidelines that will be set out. So that should make it easier for us to be able to explain, what that looks like for you. And finally, in October 2026, trade union representatives will gain new rights, empowering them to better support their members. So into 2027, the reforms will culminate in a more inclusive and supportive work environment. So what does this mean for you? So employers will be required to develop gender pay gap and menopause action plans, which promote equality and well-being. So this is where there are 250 more employees. So again, not going to be relevant to most of us here. But for those bigger organisations, bigger practices, maybe groups, this is going to be something that you will need to take on board. Another change is planned in relation to collective redundancy. So this is in addition to the protective award, which is planned for April 2026, which I covered a few slides ago. So as well as this increase in the protective award, regulations will change to set an additional threshold of proposed redundancies for requiring an employer to undertake collective consultation. So what this basically means is currently, when 20 or more redundancies are being proposed, you would have to have a collective consultation. So this is still going to be the same, but the additional threshold which they're referring to, which hasn't been defined yet, which isn't a surprise because all of this is still under consultation at the moment. But we are hearing that this additional threshold might be based on where you're proposing redundancies to a percentage of the workforce or a number that's larger than 20. So still yet to be defined. And as and when those changes come out of consultation, we'll share those with you. Pregnant women will receive enhanced dismissal protections. So this ensures job security during a vulnerable time for them. So broadly speaking, this is going to be 6 months following their return to work where they'll get that enhanced dismissal protection. A modern framework for industrial relations will be introduced to reflect today's workforce dynamics. Bereavement leave will become a statutory right. And the big one, workers will gain day one right to protection from unfair dismissal. So currently, as it stands, in order for workers to have protection from unfair dismissal, they would currently need to have 2 years or more service. So from 2027, this will be a day one right. So they will have this protection from the day that they join the practice. So there has been discussions about regulations regarding the initial period of employment being referred to as a light touch, where you can still follow a specific process to dismiss fairly. So there is discussions still where there could be a period where you can dismiss fairly, but there will be a process to follow, which is still yet to be defined. But as and when that comes out of the consultation, we will share that with you. So this is where performance management procedures are very important. And if you aren't doing so already, you should start to review your probation period policy, ensure that you are regularly reviewing your individual's performance and putting plans in place to address any gaps in performance so that, if somebody isn't quite up to where you need them to be, you're dealing with that. You're either putting plans in place to bridge those development gaps and bring them up to speed, or you're making the decision kind of now or in the next few months around whether that person is going to be kept in employment or whether you're going to look at actually ending that person's employment. Doing those things now ahead of when these rights come into force from day one will make it easier for you and reduce the risk of litigation on you. And finally, the access to flexible working is going to be improved. So this is going to be supporting work-life balance for employees. And as I mentioned earlier, the menopause action plan for companies with 250 more workers will come into place, and penalties for not complying with those specific regulations when they're set out there will be penalties. And once those regulations come out in terms of the requirements for you to publish those action plans and the frequency of that, we will share that with you. So this is the expected impact for employees. So I won't go through all of them, but the whole aim of the Labour government's employment rights bill, or the reforms, is about making work pay. So they're looking at improving conditions for workers while providing clarity and stability for employers. So these reforms are a central part of the government's broader plan for change, which seeks to raise living standards and boost productivity. So this is the timeline that has very recently been released on the government website. Although the bill is still in consultation and different variations of the bill are coming out of those consultations, this is currently the anticipated dates for the changes to come into effect. So let's break this down for you and make it more manageable and less overwhelming. So it's been broken down into 3 releases, or you may hear them referred to as roadmaps. And of course, the focus will be getting on prepared for the upcoming changes in April next year. But there will be some actions that I'll go through with you to get you ready for the big update in 2027, where employees gain unfair dismissal rights from day one. So these next 2 slides is where you need to be focusing your attention now to get yourselves ready. So as I mentioned earlier, I will be sharing the recording of this webinar, and we will release an article focusing on these timelines and the actions that you need to take. So please don't worry about having to take notes of all of this, because we will share this with you. I appreciate that this is a huge reform. These are big changes that are coming into force, and we want to make this as easy as possible for you. Break it down into manageable steps and tell you exactly what you need to do in order for you to be ready and for you to be compliant. So this is focusing on the changes that are due to come into force on the 6th of April 2026. So as I go through the changes that are coming into force and the actions, I just wanted to kind of note that where I state that policies and procedures need to be reviewed and updated in order to ensure you are compliant, this will be done for you in iComply. So if you're an iComply or iTeam member, you won't need to worry about doing this yourselves. And we will make you aware as and when these policies are released with the updates. So the first one that we've got is day 1 rights for paternity and unpaid parental leave is going to be introduced. So the action that you need to take here is to update your leave policies and communicate changes to your staff. We've then got the statutory sick pay reform coming into force. So you would need to look at adjusting your payroll systems for the changes here and inform eligible employees. We also see the launch of the Fair Work Agency, so you will need to familiarise yourself with the agency guidance and support materials as they become available. Again, don't worry about looking out for this, because we will highlight when this happens and we'll make sure that we're letting you know when this happens. We also see expanded whistleblower protections coming into effect, and so the action on this one will be looking at training your managers on handling disclosures and update your whistleblowing policy. We also see the introduction of e-balloting for industrial action becoming legal, and you will need to update consultation procedures and union engagement protocols. We also see the collective redundancy penalties increase, and you will need to review your redundancy procedures in line with this to ensure compliance. So those are the ones that we, the changes that are coming up imminently next, the ones that we need to be focusing on and spending our time on. As well as this, the ones that are coming into force in October 2026 and into 27, the big ones are where you need to be focusing some attention now. So although not scheduled at the moment, the day 1 rights, as I mentioned before, will require you to start planning now and potentially changing how you are managing your employees right now in order for you to be ready for that one. So we see the ban on fire and rehire. So one of the actions that you may want to consider here is if you are looking at or thinking about updating your terms and conditions of employment, is looking to bring that forward or trying to do that ahead of when this is due to come into force in terms of banning this process, because you won't be able to do it. So if you're worried that you're looking to make changes to employment contracts that your employees may be reluctant to agree to, and you think that this might be a negotiation tactic that you may need to consider, then you may want to consider bringing that forward. If you've got if you are thinking about that and you've got any questions about how to do that, how we can, how you actually do that in practice, we can support you with that. So please do get in touch. What you do need to be thinking about now is with the day one rights for employees, so having the protection from unfair dismissal from day one, you need to be thinking about looking at your performance management. Do you need to consider training for employees, or actually, do you need to consider dismissal? So is there somebody now in practice that, if you're really honest with yourselves, isn't doing what you need them to be doing, isn't where you need them to be? Could you consider bringing their contract to an end now, ahead of when it will become more challenging for you to do this fairly and without a claim for litigation? Or if that isn't something that you want to consider, what can you do to support them to bring them up to standard? There's also going to be a cost implication to all of these changes. So one of the things that we would ask you to consider is the financial implications of these changes and factor these into your budget planning. So you may want to work with your stakeholders around this, specifically those in finance, and look at the cost of these changes and factor these into your planning going forward. So that brings us on to coming towards the end of the presentation. So I appreciate that there was a lot of information. Hopefully, the last few slides where we focused on what's really important for you to be aware of for the changes coming in April 2026, and for those bigger changes that are coming in October 26 and into 2027. The actions that we need to be focusing on there. Hopefully that makes it a little bit easier to digest and it isn't so overwhelming, because I appreciate that there are a lot of changes that are being proposed. So before we move on to answer any questions that you have, before I go and look in the Q&A section, I just wanted to highlight the benefits of iTeam for those of you who don't know what we can offer and what we can support you with. So we appreciate that the world of HR is challenging at the best of times, without throwing in and the employment law legislation changes that I've just spoken about. So these are just some of the things that the team here can help you with. It's an invaluable service. And if you wanted to know any more about this, then or any of our other products actually, then please do just click on the link as it pops up, and we'll give you some more information about that. There's also an email address that you can contact us on if you've got any queries about any of this that I've just spoken about, or if you're already an iTeam member or an iComply member where we can support you. I just wanted to remind our iComply members as well, so that if you do need any support with anything, that you do have a complimentary 60 minutes HR advice and support. So if you're not already utilising this, please remember that it is there as part of your iComply package. So we are more than happy to help you with anything in relation to anything I've spoken about today, or anything HR related in general. So if we can help you, please do get in touch. So I'm just going to have a look at the Q&A tab to see if there's any questions in here which I haven't answered yet. There are no questions. So just before we move on to kind of finish where we are, really, it's just if you've got any questions, please do pop them in there. I'm just going to wait a few more seconds just to see if anything else pops up. No, there isn't. Okay, so if any questions come in after the presentation's closed, then I will respond to those. Okay. So Claire's asked, will all of the updates discussed today be updated on the Agilio iComply document? So yeah, apologies if I didn't make that clear. So when I said around so where I said around any actions where you need to update your policies or guidance, anywhere, we will do all of that in iComply, so you don't need to do anything. So if you're already iComply or iTeam member, where I've said you need to update policies or guidance, you won't need to do that, because we will do that in iComply for you. So we will just notify you as and when those policies and procedures are released. So is there further information about work from home flexibility? There isn't any further information about that specifically. We are expecting some more guidelines to come out as and when this bill is passed through Parliament and continues to undergo consultation. I think there is still going to be a common sense approach to looking at the type of business that we're in. So, for dental practices, and I know that we may have some vet practices on this webinar as well. Realistically, if you have a practitioner that is needed to be there present with patients, then realistically, how likely is it going to be for them to be able to work from home? So the current flexible working guidance does support you being able to decline based on that. So I'm not expecting that to change drastically, because it has to work for both parties, for the employer and the employees. Steph's asked, do we know what percentage will be for the sick pay? We don't know what that will be yet. So that still hasn't been confirmed yet. And where we said around it being a percentage of earnings, again, that hasn't been confirmed, but that is what we're hearing that is going to be coming out of this. So again, as and when that's released and we get more details, we will let you know. This isn't going to be the final webinar on this topic. So I look to do webinars every other month, so I will be looking to do another webinar in September, where again we will, if the focus isn't predominantly just on this area, then it will certainly include an update. So don't worry, as and when changes come out, we will make sure that you're kept up to date with those. So I think that is all of the questions. So thank you for popping those questions on. I do hope that does give you a clearer understanding of what is coming, what you need to be thinking about now. I will, as well as this webinar being released to the recording, we will send out a timeline that has the dates and the actions that you need to be looking at. So please don't worry about not having that. That is going to be something that you'll have, and you'll be able to look at that and think, are we on track with those changes that are coming up? Have we taken all the appropriate action? So we're going to make sure that you've got everything you need to make sure that you're compliant there. So that does bring us to an end. And I just want to thank you for the opportunity to present to you today. I do hope that you found the session valuable and you feel a little bit more confident and equipped to deal with the upcoming changes to employment legislation. So thank you and goodbye. I'll see you again.